Hello, everyone. This is Dan Newcomb in New York. Joining me on this discussion in London, in our London Sanctions team, is Barney Reynolds and James Campbell. And also joining us is Anthony Patten from the Singapore office, who has particular knowledge about oil and gas matters, working in our project group, and has been on the ground in Iran more recently than anybody else in our group, and will be talking about some of the commercial implications of the sanctions being lifted. Let us start by saying that this is a moving target, and so we are posting fairly frequently on our Shearman and Sterling Iran website developments. You can find that if you are interested in seeing some of the key documents by simply putting your search engine on Shearman. Remember, it has an A in it, Shearman, and Iran. And the first couple of entries will get you directly to our website. Our topic for today is looking ahead to the lifting of sanctions against Iran. And the reason we use that title is because what we have to work with is the agreement reached in Vienna on July the 14th, the title of which is Joint Comprehensive Plan of Action, as distinct from the prior Joint Plan of Action. But the point I want to make to you all is this is a plan, not an implementation. And so the first thing that I think everyone needs to focus on is we have not yet lifted any sanctions. There hasn't been any change of the law either in the U.S. or in the EU until the plan is implemented. And that's begun already. The United Nations has adopted Resolution 2231 of 2015, which was the first step, really, in the timetable covered by the JCPOA. The provisions of that timetable were that when the UN adopted the resolution, which was supposed to be fairly promptly, and in fact turned out to be just that, that would kick off a time period of 90 days. So we're on the 88th day, I guess it is, of that time frame, during which a number of things will be happening. The Iranian Parliament will be considering the plan. The U.S. Congress will be considering the plan. And importantly for the issues of timing, the IAEA, the International Atomic Energy Agency, will be gathering facts so that they can report on where Iran is in meeting its commitments under the JCPOA. That timetable includes an August 15th period for Iran to respond to issues about its past nuclear activities, a September 15th deadline to have the IAEA finish reviewing the documents they received from Iran and submit additional questions, and an October 15th date for the completion of gathering information by IAEA. All of those steps are very important. We'll talk a little bit later about the U.S. and EU mechanics here, and we also, of course, want to make sure that people understand that the Iranian Parliament is in the process of reviewing the agreement. Let's turn for a moment. Well, let me ask my colleagues in London if you want to add anything on mechanics of the process before we turn to some of the substantive provisions. Barney?
Hello, Dan. This is James Campbell in London.
Hi, James.
Hi. EU sanctions all relate to foreign policy of the European Union. Because of the underlying treaties in the European Union, all member states have to agree. But there's a legal obligation to lift sanctions on implementation day provided that Iran complies with commitments as documented by the IAEA.
Good. All right. Now, significantly in terms of substance, the first point that I think we should make is that the timing is coordinated, and that's quite significant. The implementation day, as James mentioned, is for implementation of the lifting of UN sanctions, EU sanctions, and the U.S. sanctions. But only certain of those sanctions. And it's important to understand that particularly the U.S. has a very complicated sanction structure in place, and the JCPOA spends a great deal of time, a great number of its 160-odd pages, in discussing exactly which sanctions will get lifted and how those sanctions will be lifted. It's worth noting as a primary matter that the sanctions that are going to get lifted in the United States are largely, not entirely, but largely what are called secondary sanctions. The U.S. has 3 types of sanctions and 2 layers of sanctions. So the 3 types in broad strokes are anti-terrorism sanctions, human rights sanctions, and what are called Iran country sanctions, comprehensive Iran sanctions. None of those were, until this negotiation at least, captured as nuclear sanctions, although some of them relate to a program the U.S. has had on weapons of mass destruction for a long period of time. So when you see in the press and elsewhere references to the nuclear sanctions being lifted, it's a little vague as to which U.S. sanctions that means. And the JCPOA has a long annex which specifies both EU and U.S. sanctions and makes great reference to specific paragraphs of U.S. legislation and specific EU provisions. The process of sorting that out is quite complicated, and we have spent some time doing a preliminary analysis which has generated a number of U.S. pieces of legislation that have been highlighted or signaled in terms of which of those paragraphs have been removed and which are not. And broadly speaking, several of the executive orders that are part of the U.S. sanctions have been substantially removed or will be substantially removed on implementation date, whereas much of the legislation has not been. Interestingly, the legislation deals mostly with what we call in the U.S. secondary sanctions. We have sanctions which apply to U.S. persons, that's citizens of the United States, companies that are incorporated in the United States, and so forth. But also a number of secondary sanctions which were put in place as the U.S. Congress particularly became frustrated that other countries were conducting business with Iran and the U.S. was being disadvantaged because of that. The JCPOA spends most of its words or pages or space on removing those secondary sanctions with respect to the United States and does not spend very much time on primary sanctions, that is, the sanctions addressed to U.S. persons. That presents quite an anomaly for us because if the UN sanctions and the EU sanctions are largely removed and the U.S. leaves in place the primary sanctions, or most of them, I should note, there's an exception for pistachio nuts, caviar, and carpets. But other than that, the JCPOA is almost completely silent on how primary U.S. sanctions are going to be dealt with. Now, that doesn't answer the question because primary U.S. sanctions are largely the product of executive authority, that is, regulations implemented under the executive branch of the government, the Treasury Department, and therefore are subject to both licensing and amendment, which is under the authority of the President and the executive branch. But at this point, the JCPOA's guidance on how that will be dealt with is largely non-existent. There are some things which we can say are clearly in the JCPOA that are important, and there are also some policy statements which are important. The first is to make the point that terrorism sanctions, ballistic missiles program, and human rights violation sanctions are not going to be lifted. And in doing that, I'm reading from the White House statement on the point. Similarly, OFAC makes the point in their recently published policy guidance that secondary sanctions, nuclear-related secondary sanctions, are going to be removed. It does not say anything about primary sanctions except that they will be publishing guidance in the future. Some of the things which we have identified already that are not getting removed are the disclosure obligations under the TRA, under the last piece of statutory legislation. That has required for several years, since 2013, I think it was, 2012, I guess it was, rather, that SEC filers, companies both in the U.S. and outside the U.S. that are registered with the SEC, filing reports with the SEC, disclose their business with Iran and Syria. And so the disclosure requirements are not apparently going to be changed. That is, the JCPOA does not list that section of that statute as being subject to the plan. And that's important because that disclosure provision has a ripple effect for many companies, because the disclosure of doing business in Iran has triggered the local legislation that roughly 30 U.S. states and localities have adopted, that either says our pension plan will not invest in companies doing business with Iran, or our procurement function will not deal with companies that deal with Iran. That legislation is not affected by the JCPOA, although the JCPOA has a sort of best efforts paragraph in the agreement saying that the federal government will make its efforts to encourage if a law at the state or local level in the United States is preventing the implementation of the sanctions lifting as specified in this JCPOA, the United States will take appropriate steps, taking into account all available authorities, with a view to achieving such implementation. I'm not clear that any of the statutes affect the implementation of the JCPOA. They're a secondary consequence of that. And accordingly, it's not at all clear how the disclosure impact will affect, as a chilling effect, companies' decisions to go into Iran. The other thing that's interesting about the JCPOA is it has a very long list of what are called SDNs, specially designated nationals, under the U.S. sanctions, that are being removed, some 1,000 names. But we've done a comparison to the lists, and roughly speaking, that's only about 20% of the names on any of the sanctions list. So that many of the names that are put on the list because of terrorism or human rights or other issues, not nuclear issues, will remain on the list. Significantly, about 86 banks are named on the list. NIOC, the national oil company that Anthony will speak about in a minute, are on that list. So there are many changes that are going on. I'll stop there and ask Barney and James if they will describe sort of what's going on in the EU as a matter of substance.
Thanks, Dan. It's Barney. So at least initially, the changes to US sanctions that Dan's outlined are far more limited and complex than what's happening with EU sanctions. In the EU, the position is much clearer and simple to explain. On the so-called implementation day, which is the big bang moment for Iran's economy as the EU and US begin to lift sanctions after verification by the IAEA that Iran has met its nuclear-related obligations, at that moment, the EU will terminate the majority of its sanctions, and it will no longer be prohibited for EU persons to participate in basically the following activities which are currently prohibited by a regulation, an EU regulation promulgated in 2012. First, from this moment, there can be transfers of funds between EU persons and entities and Iranian persons and entities. That includes financial institutions. As a result, Iranian nationals and EU member state nationals will be free from that moment to conduct business with one another, with the exception of transactions involving proliferation-related goods or services. Banking activities, including the establishment of new correspondent banking relationships and the opening of new branches and subsidiaries of Iranian banks in the territories of EU member states, will be permitted. The provision of insurance and reinsurance becomes permitted. Transactions in public or public guaranteed bonds. The import and transport of Iranian oil, petroleum products, gas and petrochemical products. The export of key equipment or technology for oil, gas and petrochemical sectors. The investment in the oil, gas and petrochemical sectors more generally. Sanctions related to shipping and shipbuilding and the transport sector. The export of gold, precious metals and diamonds, and the delivery of Iranian banknotes and coinage. A very far-reaching list. In essence, this basically excludes sanctions prohibitions in relation to arms and military equipment, metals and software, which will stay in place for a further period of up to 8 years, and as will the asset freezing and related restrictions in relation to a number of targets who've been designated in relation to proliferation activities. In addition, EU political sanctions imposed in response to human rights violations by Iran by Council decisions in 2011, numbers 235 and 359, will remain in place. And the ban on the supply of certain goods used for internal repression will continue in addition to the asset freezing measures on designated persons and entities.
So in essence, basically all the financial sectoral restrictions become lifted potentially within 6 to 9 months on implementation day, which basically envisages Iran doing business freely within the EU in the financial sector. Then there are other things which may take further time to lift, which relate, as Barney described, to human rights-related abuses, and those are 8 years after the adoption date, so 2023. As a result, many Iranian sanctions will continue to be enforced for quite a while, but the important thing is that the financial sectoral restrictions basically disappear potentially within the next year if the IAEA say so. It's worth also mentioning, which we haven't covered yet, is that the JCPOA contains provisions for a snapback period. So the Iran sanctions relief is subject to so-called snapback in the event of any significant non-performance by Iran of any of its commitments. So if the IAEA say that Iran's doing everything it needs to and then subsequently determines that it isn't, and after a joint commission hearing on the issue consisting of the P5+1 in Iran, if they fail to resolve the matter within 30 days, then the matter gets referred to the UN Security Council, which will vote on whether to continue sanctions relief or reimpose sanctions on Iran. And this is a key point which we've had lots of interest from clients. How much should it impact on our investment appetite if we're going to be doing business with Iranians, investing after implementation day in doing new things with new clients or clients that we've previously dealt with, and then suddenly all these sanctions come back into play overnight. And this is one of the key things that need to be borne in mind when developing a compliance strategy for dealing with complying with the phase out and the lifting of Iran sanctions.
And just to supplement what London has said, the U.S. secondary sanctions that complement the areas Barney has been talking about are basically being lifted. Again, we have done an analysis of the legislation and the executive orders. We will be posting those statutes marked to show which provisions are coming off on our website in the next few days. But the basic point is that there's large symmetry between the EU sanctions being lifted and the U.S. secondary sanctions being lifted. One anomaly in that is that the JCPOA talks about the non-U.S. subsidiaries of U.S. companies and suggests that they may be permitted to act based on their local law provisions. But the JCPOA does not really discuss the issue of facilitation, which is a very broad concept about how integrated parents and subsidiaries are. And it will not be at all clear until we get some guidance from OFAC as to whether a European subsidiary of an American company will be governed by European rules or U.S. rules. A very complicated problem because that is one of the provisions under that same statute that dealt with disclosure. There's a paragraph where Congress extended U.S. primary sanctions to the subsidiaries of U.S. companies. And that will require a change in legislation. And interestingly, the 90-day period to implementation day is 30 days more than the time that is provided by the legislation, the 60 days that Congress has to review. We suspect that the reason for the difference in timing may be a recognition that there's a high risk that Congress will disapprove of the transaction. The president will veto that disapproval, and there will be then a override attempt. How the JCPOA will be implemented in the U.S. will be a political football for some time to come. Barney and James, unless you guys have something to add, I thought maybe we would let Anthony talk a little bit about the commercial on-the-ground reality in Iran, assuming implementation, give us a chance to comment on what Anthony says, and then open it up for questions. So, Anthony, why don't you go ahead and tell us a little bit about what it's like to walk around Tehran.
Thanks very much, Dan. So I'll be looking, I think, at what some of the investment opportunities might be for businesses in Iran. As Dan mentioned, I had the interesting experience of visiting Iran many times up until around 2007, working on various of the oil and gas projects that were going on there. My focus is generally on the energy sector, so I'm going to focus primarily on that today. There are some other sectors that are thought to be exciting. Two of the ones that are mentioned have been mentioned are the automotive industry and also the civil aviation sector. And visiting Tehran, there's also a visible lack of Western brands, whether it's hotels. There's certainly no Coca-Cola or McDonald's, so there's certainly brand opportunities for businesses in what's quite a large market of 80 million people. Turning to the oil and gas industry, perhaps just some quick facts to put this in context. Firstly, some of you may not know that BP, today's BP, was actually originally known as the Anglo-Persian Oil Company. And Iranian oil and gas was really the foundation stone of the company that became BP, although many of those assets were nationalised in the 1950s. There are very significant petroleum reserves in Iran, so sort of a large untapped opportunity for international oil companies. Iran has the fourth highest oil reserves of any country in the world, and the second highest gas reserves of any country in the world. But they've had a lot of challenges in terms of production. In fact, Iran today produces about 40% less petroleum than it did prior to the 1979 Islamic Revolution. And more recently, following the EU sanctions, production has fallen by as much as 20%. So lack of access to Western technology and foreign investment has hampered production of Iranian oil and gas. In terms of anticipated activity, we expect to see some very significant efforts by Iran in relation to natural gas, and in particular liquefied natural gas. It's not far across the border to look at Qatar. Qatar has significantly developed new gas projects, all based on gas coming from a field known as the North Field in Qatar, which is actually shared with Iran. It's known as the South Pars Field in Iran. So Qatar has actually been making its success based on a reserve which is shared with Iran, but Iran has not been able to develop. We think LNG will be a big focus, therefore, for Iran. A number of the European oil companies had been involved in working with NIOC on developing those reserves, and we think will want to play a serious catch-up now. Strangely enough, although Iran is a major oil producer, it actually imports gasoline and other refined products. So one would expect that there are refining and refinery investments to be contemplated. And further in the downstream, there has historically been an interest in petrochemicals and gas liquids. So what's the practicalities of doing business in Iran and the energy sector? Well, I think any foreign investor will need to deal with NIOC, the National Iranian Oil Company. NIOC is the key player in the industry. It operates most of the existing fields. The Iranian constitution actually limits the extent to which foreign persons can be involved in the sector. Certainly owning oil and gas reserves is barred, so dealing with NIOC is part and parcel of doing business. NIOC is, like many national oil companies, a large bureaucratic organisation. There has been some good news in the sense that the management of NIOC has since 2013 been changed, and the persons involved in running NIOC now are thought to be more friendly to dealing with foreign investors than the ones that had been in place during the Ahmadinejad regime. In my own experience, NIOC are quite challenging to deal with. Negotiations can be protracted, can often involve, I think as was the case with the nuclear negotiations, can often involve one step forward and two steps back. And NIOC staff are generally risk averse. In one case I was involved in, NIOC staff were asked to sign off on individual provisions of contracts to be signed, and so people were generally unwilling to put their heads above the parapet. But there are some promising signs. The previously used Iranian buyback contract, which underpinned upstream investment and weighed risk heavily on the international oil companies, is rumoured to be replaced with a more investor-friendly petroleum contract, which is to be released later this year. And generally speaking, given the difficulty of finding and producing new reserves, a new market such as Iran is very exciting for the super majors. Shell and Total were heavily involved in Iran pre-EU and UN sanctions, and what will be interesting now is to see whether they'll be joined by their US rivals such as ExxonMobil and Chevron. So that's sort of a very quick overview, I think, of where we think the opportunities might be in Iran. And Dan, I might hand back to you.
Yeah, and there are a couple of interesting aspects of what Anthony said. I mean, point one is that 20% drop in their exports is very much a reflection of the, U.S. and the EU both clamping down on financial transactions. particularly SWIFT, the interbank transfer mechanism. Those sanctions were very much covered in the JCPOA. They are going to be lifted, and so we would expect that if the program is implemented, the financial tail on the petroleum business, the petroleum resources of Iran, will basically be freed up. The interesting question that comes up for financial institutions is the issue of U.S. primary sanctions and SDNs. If U.S. dollars are being used to conduct the transactions in Iranian petroleum, the primary sanctions, again, will have a significance. And how exactly this will be aligned is not perfectly clear from the JCPOA. As many of you know, not only are U.S.-based banks, but many European-based banks are very sensitive now to their OFAC compliance because of very draconian enforcement proceedings that have been brought in recent years against a number of European banks. Again, an area that is yet to play out in the next 90 days. We will presumably get some better guidance on exactly how the interchange between non-U.S. banks and the U.S. dollar clearing system will work out. Barney and James, have you got things you would like to comment on with respect to Anthony's description of the commercial realities?
Yeah, just picking up on a few points. Just building on your point just there that European subsidiaries of U.S. entities is something that we should pay particular attention to. There's a notice that the UK Department for Business Innovation and Skills has issued this week, under which the UK government has warned that even as sanctions are lifted, Iran will remain challenging as a place to do business, and banks and other financial institutions may remain reluctant to handle Iran-related transactions whilst full US sanctions remain in place. So, I mean, that's certainly something, the extraterritorial element of the US regime and the subtleties as to the rollback and the differences across the Atlantic are clearly important there. And then next, go ahead.
Oh, Barney, I was just going to say on that, when I was previously involved in Iran, there was some involvement from the large European export credit agencies in terms of financing large projects. And so given some of the issues, I expect that they will also look again at Iran, particularly for things like the large LNG projects. And we're also already hearing that the Asian export credit agencies, whether in Japan, Korea, or in China, are also likely to be sort of dusting off their plans for financing of Iranian projects. So we do see a role here for the ECAs, but certainly there is great care to be taken.
Yeah, and then another issue that crops up in the context of people wanting to go back into Iran is the position of pending sanctions infringement investigations by EU member states. And in principle, those will carry on, although various sources have indicated that they will be reviewed in accordance with applicable national laws. It may be that some of those will be soft-pedaled. But as a matter of law, obviously, any infringements taking place right up to the moment when the rules are relaxed are technically infringements and liable to be subject to infringement investigations and enforcement actions. So that's a point, obviously, to be watched, and it's something we're seeing quite a few queries on.
Barney, let me just interrupt you for a moment to say, in a few minutes we will open the lines to questions. So if you're thinking about a question, the operator will explain the mechanics of that to get into a queue, but we'll spend just a few more minutes in wrapping up the conversation. Barney, go ahead.
So there's an issue relating to disputes in Iran. The nuclear-based sanctions in Iran were enacted in 2012, and lots of investors in the US and the EU were forced to withdraw from Iran quite suddenly, basically overnight. That's the nature of economic sanctions, and as a result, they had to terminate and suspend their relationships. So lots of US and EU persons who found themselves in that position have dormant or pending disputes across a wide range of sort of legal categories against such investors. There's an issue there insofar as if you were to enter the Iranian market, is there a concern that you're going to be sued all over again by these people? That may or may not be true, but there is a possibility that you could resolve these issues on a commercial basis rather than through litigation because of the opportunities presented in Iran. So there's been concern there'll be a rush to litigation, but actually in practice we believe that that's unlikely because of these new business opportunities for all parties.
Yeah, and I think James, that the way that on the energy side, a lot of the oil companies have been very careful in the way that they've managed their exits, and have tried to maintain good relations with NIOC on the basis that if there is a dispute or if there was a sort of unilateral sort of action, that it would be very difficult for those companies to come back in. So I think in the oil and gas sector that's very much at the front of people's minds.
There is, of course, in addition to that, there's the key issue that if you are going to deal with Iranians after implementation day, of course, in a business context, and you have to conduct fresh due diligence on these people. It's not good enough just to rely on your due diligence from several years back. Everything needs to look at all over again.
And on that note, I can't resist making the anti-corruption point, which is with NOIC, the National Oil Company, having such a large role in what we see as the future business. Do remember that is a foreign official within the meaning of the FCPA and the comparable provisions of the UK Bribery Act. So due diligence will have to include careful decisions about how you deal with the anti-corruption aspects of your diligence program, where the economy has such a high proportion of government involvement. On the dispute resolution point, it's useful to know that Iran has over 60 bilateral investment treaties, but is not a primary member of ICSID. So in terms of dispute resolutions on investments, they have many tools, but not the one that a lot of investors look to primarily, which is the ICSID arbitration provisions. They are a subscriber to the New York Convention on Arbitration, but obviously the dispute mechanisms are something that you will have to take a look at very closely. The other question that I'm getting here in New York is, during this 90 days, during the period when it's not clear, what can we do? And the short answer I have been giving is you can refresh your Rolodex. We talk about it in terms of First Amendment rights. You can talk to Iranians, you just can't do deals with them. And in fact, the headlines suggest that a number of companies have already started the process of refreshing their their Rolodexes. And James, while we're paused, perhaps I know somebody had asked a couple of questions to you in advance of this. We can start by trying to address those questions.
Yeah. Brilliant. Thanks, Dan. Actually, it relates to the point, it's a very similar question to something you just answered, but I think we should probably discuss in possibly a little bit more detail. It's been raised. The question of, before Iran sanctions are fully lifted, can we have conversations with sanctioned Iranians about possible business opportunities? We received quite a few questions on this, and as you say, in the US, you can refresh your Rolodex, so you can have conversations with people from the US side. But on the EU side, if you're subject somehow to EU rules, whether you're a business based in the EU, whether you're an EU national, wherever you are in the world, whether you're a company outside of the EU doing business in the EU, these are all ways you can be caught by the EU rules. you need to be a little bit more careful because the prohibitions on doing business in Regulation 267/2012, they deal also with brokering transactions, and brokering doesn't cover the traditional in-between role of being between one person and another person. It also involves a negotiation, so you can be broking on behalf of yourself somehow within the meaning of the EU rules. And if you're broking in relation to a prohibited thing, so if you're having a business lunch with an Iranian you haven't met for several years and somehow you mention a possible business opportunity, this could fall within the scope of the rules. So we just generally consider that a degree of caution is needed when you talk to Iranians in setting up any meetings to make sure that what you do talk about isn't closely related to anything that's prohibited in the rules. And there are various ways you can do this from a compliance perspective. It goes way beyond just having minutes and circulating minutes and agreeing beforehand what you talk about. It's a little bit cumbersome, but you just have to be very careful that there is still an enforcement risk up until implementation day. And there is, in theory, a possibility on the EU side that, and I imagine on the US side also, that you could be prosecuted for something that you did before sanctions are lifted, even if sanctions are lifted. What's needed is a careful strategy from the US and the EU side, because you can be subject to one or either or both sets of rules, and it's always going to be fact sensitive. And there's a comparable doctrine in the U.S. Which really arose during the Vietnam sanctions being lifted, and that is that executory contracts which say if sanctions are lifted, we agree to do X or Y, are not permitted. So refreshing your Rolodex does not include winks, smiles, handshakes, understandings, contingent contracts. And it's very important that anyone thinking about going to Iran carefully review the restrictions on U.S. persons. Travel is not restricted. There are some economic issues in terms of travel expenses, but not significant ones. Very different than, for example, Cuba travel. We're coming up on the end of the hour. Anthony, would you like to wrap up? Anything you want to add to what we've been saying?
Oh, thanks, Dan. Look, I think it's the next. Excuse me,
Anthony, we're not hearing you.
The next several months, I think, are going to be very interesting. While people are positioning for opportunities in Iran, you mentioned the implementation date, the expected implementation date. I think a lot of investors will be busy positioning in the next several months, taking into account of what you were saying about refreshing Rolodex and the European rules as well. But I'm expecting that a lot of people will be visiting Tehran, will be positioning themselves for those opportunities, and working hard to become familiar. It's a jurisdiction where there hasn't been a lot of experience in recent years. There's very few local lawyers, for example, with expertise in dealing with foreign investors. The legal system, the company law is based on a 1940s statute. There's very little, Sharia or Islamic elements in the legal regime at the moment. So the regime is more based on the European Civil Code, which will be familiar to some people. So there's certainly an opportunity for people to do good diligence in the next little while on the optimistic assumption that the sanctions are lifted in the way that we expect.
All right, Barney and James, anything else you'd like to wrap up with?
No.
All right. We thank you all for joining us today. This will be the first of a series of calls that we expect to do with this topic over the next 90 days. At the same time, you can sort of follow our developments on a more real-time basis on our website that I identified for you. And if you are not getting our client notes and would like to do so, drop me an email at dnewcomb@shearman.com, and we will make sure you get added to our mailing list. For those who are in Asia or otherwise have difficulty with this, we will post on our website an audio replay of this conversation as soon as the technology can do it, which I expect is in the next day or two. Thank you all for joining us, and stay tuned because it's far from over. Goodbye.